Welcome back. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks the Law. Well, I'm driving a little over an hour out to one of the more distant courts I go to, and I actually have my law partner in the car, Joshua DeLue. He's phenomenal. And we were just rapping about some juvenile law matters because our firm has a very strong juvenile law practice. Josh has been a GAL for a number of years. I worked as a GAL. We've both been parent attorneys, and I've also represented the juvenile office. So we've literally seen every aspect of juvenile law that an attorney has. And then there's also some family connections, so we've seen other areas of juvenile law as well. One of the things we were discussing before we turned the camera on was juvenile law and parents with medical marijuana cards. In our practice, we've seen a lot of divorces lately where one parent uses medical marijuana or uses marijuana and doesn't have a card. We discuss whether or not they should get one and why. But in juvenile cases, the additional factor of medical marijuana card is one that Josh and I discussed, and he agrees that if you have a medical marijuana card, you absolutely need an attorney in a juvenile case.
Yep, absolutely.
Now, for people that can't afford to hire a private attorney, some circuits will appoint attorneys. Do you agree with that?
Yeah, it's odd which courts will appoint and which ones won't. In fact, there are some counties that even if an individual can afford, they appoint a parent attorney.
And I'm of the opinion that there should be an attorney appointed in every one of these cases for a number of reasons. First, it is eminently easier to resolve a case if the parent has an attorney. They can advise the parent, they can work with the parent, they can explain what the court's ruling is, what they're being asked to do, and they can also try to prevent the case from
Going stale.
Children's Division's creep. Sometimes Children's Division, and I'm not going to say it's out of malice, it's people that care, but sometimes the case creeps in other areas, and now they want you to do this before you terminate the case. And then they want you to do that before you terminate the case. They want you to do something unrelated to what came into care. And an attorney can help confine it to what they're focusing on, right?
Absolutely. And I'm of the same opinion that a parent attorney should be there, also because it is a potential that the end result is what I like to call a death sentence for a parent, and that's termination of parental rights. If you're going through the progression of a case and the parent hasn't had an attorney and it gets to the point of a TPR, I would have major concerns about what happened before it got to the point that the judge ordered TPR.
Yeah, a number of judges have referred to the TPR as a civil death sentence. That is where termination of parental rights, the court is holding that you no longer have children and the children no longer have parents because you have performed so poorly in your parental duties so as to have surrendered that right, or you're abusive or along those lines.
And I will say this, I'm not aware of any circuit not making sure for the actual termination of parental rights case, the parent doesn't have an attorney. I believe in all instances for that case, there is a parent attorney regardless.
It's required, yes.
But
absolutely have to have an attorney.
But knowing the process from the inside, an attorney getting that file and those documents that have been potentially produced over a year, if not longer, and sifting through to make sure every step was taken can be difficult.
Well, yes, and then even over the course of those documents here, you know as well as I do that the attorney for the juvenile office, when they go into court, the first thing they say is, Judge, as a preliminary matter, I'd ask the court to take judicial notice of its record, in particular the filings, the statutory mandated court report pre-filed by Children's Division on XY date, and then they'll enter it into evidence. Okay. Now, as a parent attorney, it's a meaning. I mean, you're going to get overruled on your objection every single time, but you're going to object to the hearsay within that report, and you can challenge aspects of that report. That's what the hearing is for.
Absolutely.
Now, if you don't challenge it, then when that hearing's over, that report is gospel for the record. And then when you come into the TPR, they've got the reports, it's unchallenged, and the attorney at TPR is going to ask the court to take judicial notice of the underlying cases and all the documents therein. Okay? Now you're fighting against a tidal wave when you should have been out battling each wave at a time.
Absolutely. That's a good analogy.
And I use the wave analogy because it's a juvenile court and it's going to roll over you anyway. But with an attorney and with the right steps, you can do a lot to mitigate, and break the water.
So what is your experience of the juvenile courts handling the medical marijuana card at this point?
Medical marijuana is a different animal. There is no consistency between circuits, between judges for medical marijuana. We don't have any guidance from the appellate courts or the Supreme Court, so it's very much being handled, ad hoc by individual judges and courts. For example, if there is a new case and the parent has a medical marijuana card, the court's going to look at, is the use of this substance impacting the child? Are they keeping it locked away? Do they only use, their medical marijuana away from the child? Is there supervision for the child while they are under the influence of their medical marijuana? What are the levels that they're using? What is their purchase levels? These are all things that the court's going to investigate and consider. And if it is not impacting the child, then the court's probably, I have one judge that probably won't care. I've worked with. I've got some judges that will. But when you look at the law and you look at the juvenile statutes, it seems to come down to whether or not the use of that substance is having impact on the welfare of the child. If it is not, then that's something that an attorney can argue that this isn't impacting the welfare of the child. Therefore, it's a non-issue for the court at this time. So that could be argued. The question is going to be, is the parent going to be able to present that argument on their own without an attorney, or will the attorney do the work and get knowledgeable enough to understand our medical marijuana laws and the fact that in Missouri, you have a right to use medical marijuana. You don't have a right to use any other substance, but you now have a constitutional right for medical marijuana.
No, and I know from watching your previous Pat Talks laws that you've read up extensively on the medical marijuana. When you're issued a card, are you issued you can only have so many ounces a month, so many ounces a week, or is it just to be determined?
Yes, maybe, no, and yes.
Because
like anything law, look, there is an amount that's listed, possession amount, 4 ounces, 30-day supply. You can carry up to 2 months, so a person could have 8 ounces in their possession. However, that's purchasing from the dispensaries. You also the possession amounts also apply to home growers, but really, home growers may not report that they're harvesting more than that. So then they're taking their own chance when they do that.
Why I ask that question is, I have had the experience where when caseworkers would have their meetings with parents for other drugs, such as prescription drugs, the caseworkers would actually count the pills. When a parent would take a drug test, they'd also be able to test the levels to make sure, hey, they're not buying pills off the street. Marijuana seems like a very, very different animal because every single strand has a different level of THC.
Well, yes. And it is a different animal because unlike prescription drug, there isn't a prescription for it. There isn't a doctor in the country that can write a prescription for medical, well, I shouldn't say that. There are very, very limited doctors that can write a prescription for medical marijuana. There were the glaucoma tests in the 80s. Some of those people are still receiving marijuana cigarettes. There are some limited glaucoma studies in various states where some people are still receiving federal marijuana cigarettes as testing. So there are a few doctors that can write that, but it's not going to be the average doctor that people see, especially in Missouri.
Mm-hmm.
So, but a doctor can't write a prescription for a Schedule I substance like that, and you're not getting a prescription for medical marijuana. And I've had that conversation with a prosecutor where he's like, well, if it's a medicine, what's the dosage amount? What's the daily dosage? How do we know that's being delivered properly? And he's got a valid point. In Missouri, you can possess up to 4 ounces a month. You can purchase up to 4 ounces a month at the dispensary. So you kind of have a 4 ounce a month limit, but that's also kind of a grayish limit because the Department of Health and Senior Services has in your statement that if you have a medical marijuana card, you can have that 4 to 8 ounces in your possession at a time. But, it doesn't matter where you bought it. I expect they're going to change that reg at some point as more dispensaries and more cultivation facilities come online. But right now, a person might buy 4 ounces at a dispensary. They might buy another 16 off the black market. Who knows? But your question about levels is well taken. If it's mild anxiety, what is the level that's appropriate? It's really just a question of, do they have a card? And, then it's Wild West. We have no knowledge beyond that.
That's where one of the courts that I worked with, the judge wanted to establish a baseline of what a parent's level was when they had a medical marijuana card, so it could be evaluated in random either hair follicle or urine tests to see if they're spiking way above that baseline or they're dropping down and potentially not really using it to use his term, medicinally, but using it recreationally.
Well, yeah, and that's going to be one of the stumbling blocks until we have guidance from the appellate courts and the Supreme Court, or some clarifying legislation from the Missouri legislature. That's just up in the air. The legislature may have to pass something in regards to the juvenile court system.
Have we gotten to the point where we actually do have, I know in our area, I'm not aware of an actual dispensary that has opened its doors and started selling, or maybe it's just because I don't pay attention.
We do. It's in the old donut shop over near the softball field.
So we have one and it's already up and selling.
That's my understanding, yes.
So prior to us getting them actually up and running, how did you see Judge handling when an individual had his card and say went to Illinois to purchase their medical marijuana and then came back into the state?
completely disregarding it because they just committed a federal offense.
Okay, that is the same position that the judge I work with as well.
The reality is, I mean, and this is one of the distinctions. If you have your medical marijuana card before you get involved with the juvenile justice system, you are in a different situation than if the court has adjudicated you for parenting under the influence and then you go to cover it by getting a medical marijuana card. Those are very different situations. And quite frankly, if there is already an adjudication that your substance use is interfering with your ability to parent, the court may disregard your medical marijuana card and tell you you can't use that substance. Just like the court may tell you you're not going to be drinking alcohol while you're going through juvenile court. Those are two things the court may do. And until we have a decision from the appellate court, we can't say what they're going to say regarding to that action on medical marijuana. But I can tell you the appellate courts have certainly upheld the juvenile courts telling a parent they can't use alcohol if alcohol is one of the reasons for removal and they're not correcting that problem. That could very well lead to termination and result in the termination of parental rights.
Absolutely.
So you're right, but that's getting the card is not a panacea. It's not a
get out jail free card.
Correct. You're not running around yelling "Ollie, Ollie, I'm free." And even if you're not using medical marijuana or you don't have a card, if you are in the juvenile justice system for any reason, get an attorney. You can't say that plainly enough.
There's a lot of aid that the attorney can provide to a parent, whether it is moving a case forward through participating in FSTs, which are family support team meetings, being a voice for you when you have your review hearings, being able to ask the proper and right questions of both the caseworker and the juvenile officer.
Or even avoiding the whole thing by fighting and winning the adjudication hearing.
Absolutely.
Okay, that initial adjudication hearing, if there were services that could have or should have been provided prior to the adjudication, then your attorney can raise that argument and say, look, my client's already solved this problem between the initial filing and today. These services should have been provided prior to this filing and very well may be able to defend you. Or they could even argue that this wasn't something that rose to the level of removing a child. Somebody overreacted or they misunderstood the law, misapplied the law. There's a lot an attorney can do. That doesn't mean that hiring an attorney is a automatic I win. It's not the get out of jail free card, but it leaves avenues for you that you don't have. And if you can't afford an attorney, the parent should absolutely request the appointment of an attorney at every hearing. Make them build the file where they're saying, we're not going to appoint you an attorney. No, you can't have an attorney. You're indigent. No, you can't have an attorney. Because that'll make a difference if it comes to TPR.
Absolutely. It's a lot easier as an attorney to have been involved in the process either early on or from its inception rather than starting towards the tail end, which is, if you make it that far, what the TPR actually is.
Yeah. And there are things that can be fought the whole way. How many times have you seen safety plans and seen the evolution of safety plans to where now we're requiring to do something we barred them from doing 3 months ago?
Yep.
And that happens. So first, if you have a medical marijuana card, understand in Missouri and anywhere else in the country I'm aware of, you don't have a prescription. And a prescription is it's a magic word, okay, for lack of a better way to phrase it. That is a doctor saying you must take this to be healthy. Until Big Pharma invests in medical marijuana, I don't think that's going to happen. Once Big Pharma invests in medical marijuana, that'll happen with a quickness that'll blind you. You'll get whiplash.
That's when everyone that wants the card is going to move to the recreational marijuana states.
Well, we're gonna get recreational.
We did face one of those issues when I was working in the juvenile system. It was a parent who had moved to a state where recreational was legal, and coming back here trying to visit his children and having a drug test that was dirty.
Right. And they told him that as long as he was in the juvenile court in Missouri, I'm guessing, tell me if you think if this is what happened. As long as he was involved in juvenile court in Missouri, it didn't matter if it was legal, and it was probably Colorado, he was not allowed to use it.
Washington State, actually.
Okay.
But yeah,
and they said
absolutely.
he wasn't allowed to use it.
Yep, that is what happened.
Because it's a court order from the state of Missouri.
So Dad had flown from Washington monthly to see his kids, and one time when he had a failed drug test, he wasn't allowed to see his kids, even though he'd made the trip.
That sucks.
So even though we have the medical marijuana stuff, there's so many other things regarding marijuana because it is treated so differently from state to state, not only jurisdiction, circuit to circuit here where we work, that there's tons and tons of questions that are still yet to be developed by the court. Why we wait for, as you say, the recreational marijuana to come to Missouri.
Well, and even when we have recreational marijuana in Missouri, I still think you have the problem. You're still going to have a judge that's going to say, no, you're not going to use marijuana while you're in this court.
I don't disagree.
And if substance abuse is one of the reasons for removal, or one of the reasons you're in juvenile court, even with a card, they're likely going to hold to that.
I don't disagree with that.
Now, if your substance abuse leans more towards abuse of pills or medication, the same thing's going to apply. They're just going to have medication management.
Yep.
They're going to make sure that you're getting 7 pills a week and you're taking 7 pills a week.
Yep.
And they're going to test you to make sure that the levels show that's all you're taking. And you are, in fact, taking it. I've had a couple clients where they wouldn't take their prescribed medication daily so they could have a party on the weekend and pop a bunch of them. Yeah. But, hey, we're 23 minutes in. You're still watching. Hit like, subscribe. We appreciate it. I'm going to have to cut this off because it's going to get too long. And quite frankly, we're not that far from the court we're going to. So thank you very much for watching. Please drop a comment. Comments help the YouTube algorithm. The likes do as well. And we'll be talking to you again real soon.